Aloha, everyone. It's 6 o'clock, and I know that some people are probably still going to be joining us, but we've got a pretty full program. So we're going to get started right on time. Want to just first start by saying aloha kako, mahalo, mahalo to all of you for taking the time out of your evening to be here with us today for this webinar. I see that we've got over 20 people on the line right now, and every minute more people are joining from what I can see on the attendee screen. So thank you. I see some familiar names. Hello, Teresa. Hello, Mark, Carrie Ann, Ivalani. I'm not going to be able to say everybody, but we see you, we see your names, and we're so grateful that you have made this time to be with us tonight. So my name is Makalika. I'm the Executive Director at Native Hawaiian Legal Corporation. I joined NHLC in December, so I'm really excited to be here with our team. This is the first webinar that I've had a chance to do with the team, and we are really excited about sharing this information about management of DHHL leases. So wanted to do a little bit of housekeeping just to set the stage before I turn it over to Henderson Hui, who is our expert in this area and going to be our presenter. So first, this content is legal information, not legal advice. So please contact our office if you have a specific legal issue that you need help with. We are open during business hours, Monday through Friday. And if you call our office, you'll talk to Grace, who is our intake specialist, and she will make sure that you get your question routed to an attorney for help. So, please think about this as being good information, but if you've got a lease challenge and you need help, please call our office. The other thing we want to mention is that rules and law referenced in this webinar, they can change. So everything that we're sharing today about legal information, that is accurate today. Some of the law has been very mature and established for a long time, but some of these rules are definitely subject to change. So please contact us to confirm that all of this continues to be accurate if you hear anything here that you want to copy or reproduce. The other things I'd like to share is we're going to record this presentation. So it's being recorded right now. I think when you logged in, you probably got a little notice saying that it's being recorded. We are then going to post this on NHLC's website and our YouTube channel. And that means that if you hear anything and you need to reference it again, you'll be able to find it. You can share it with others if you think that this information would be useful for other people you know to have. It also means, though, that to protect your privacy, we don't have chat enabled. And if you'd like to submit questions, which we will take at the end, we'd like you to use the Q&A function, which is in the top menu of your presentation screen. So I think most of you can see that there's a Q&A, looks like a chat bubble at the top of your screen, and you can use that to submit questions. And then if you are having, and well, the way that my face is showing, I think it's a little blocked, but you can also email us at info. This is funny. Let me change my screen so you can see the slide. But you can also email questions during the presentation to info@nhlchi.org. We'll be monitoring that email address in case you have any trouble with the Q&A function. And that's another way you can submit a question. We'll take questions for about 20 minutes at the end of the presentation. If your question is not answered, again, you can call us during business hours and we are happy to help. So with that, a little bit of housekeeping, I now want to turn it over to Henderson Hui. Henderson is an attorney that has been working with NHLC for 2 years as a special fellow through the Equal Justice Works program. What that means is that he is here specifically focused on a project topic, and his project topic is the needs of homesteaders. Henderson is a graduate of Kailua High School. He is also a 2020 graduate of UH Richardson School of Law. And Henderson finds this topic to be very near and dear to his heart and his ʻohana. He's a 4th generation homesteader from Waimanalo. So Henderson, I turn it over to you. Thank you so much for sharing all that you have studied in your 2 years with NHLC this evening.
All right, thank you, Makalika, for that introduction. And aloha to everyone joining us here tonight. So the purpose of today's webinar is to provide information on successorship of Department of Hawaiian Homeland's homestead leases, the issues that can arise during the lease successorship process, and how to request legal services from NHLC. I would first like to tell you a little bit about the Native Hawaiian Legal Corporation. For the past 48 years, NHLC has been the only public interest legal services organization in the world that is dedicated to the protection and advancement of Hawaiian identity and culture. So NHLC is committed to supporting homesteaders to ensure protection of their rights and accountability of the Department of Hawaiian Homelands to its beneficiaries. NHLC offers representation to beneficiaries and communities in lawsuits and administrative proceedings for a wide variety of matters affecting their interests. These matters often require months and sometimes years to resolve. As an independent law firm, NHLC is not a part of ʻohana, DHHL, or any one homestead association. What you'll see here are the main areas of law that our firm practices in and the work that we do. NHLC provides legal services in DHHL and other state land trust entitlements, assistance in land title, defense in quiet title actions. We protect cultural sites such as Mauna Kea. We advocate for the protection of ahupua'a and kuleana rights, as well as protection of traditional and customary practices. The services that our office generally provides are legal representation in court, administrative hearings and negotiations, counsel and advice, and testimony on legislation or administrative rule amendments. So the takeaway here is that NHLC is a 501c3 nonprofit independent public interest law firm that is dedicated to Hawaiian rights. We are a small but mighty team of 6 attorneys. You can contact us by phone, email, or go to our website for help. The contact information will be available at the end of this presentation. So now let's turn to successorship. Under the Hawaiian Homes Commission Act, I'd like to acknowledge that it can be difficult to talk about death and dying, but these discussions can help to ensure the success of your ʻohana in keeping your homestead for generations to come. Now, there are usually many questions that come up for families when it comes to successorship. And oftentimes families will call our office because the issues that arise happen due to a lack of planning for the success of the successor. So the information that we're going to go over will hopefully help homesteaders understand the process of successorship, as well as some of the common issues that come up so that they may better plan with their ʻohana. Now, this information has a lot of rules, and we'll be walking you through them. And although we may not necessarily agree with some of these rules or the outcomes that they may have because they sometimes clash with our Native Hawaiian values, we are here tonight to help you to understand them so that you'll be able to navigate them with your ʻohana. All right, so what is a successor? A successor is the person who takes over a homestead lease after the lessee passes away. And there are 2 ways that a person can become a successor. The first is that the person can be designated by the lessee. The second, in absence of a designated successor, the Hawaiian Homes Commission may choose one. This applies to both regular leases, including residential, agricultural, pastoral, and undivided interest leases as well. So why should a lessee designate a successor? Designating a successor will help to avoid confusion and eliminates any uncertainty as to who the successor should be, and it also allows for planning with your ʻohana. So last, it helps to shorten the time that it takes for a successor to take over the lease, and we'll talk about that in the next slide. Now, what happens after a lessee passes away without a designated successor? This is a bit of a long process, and it first starts with the Department of Hawaiian Homelands receiving the death certificate of the lessee. It does not start when the family verbally lets the department know. The department needs that death certificate to start this process. After they receive the death certificate, it will go up for public notice. A public notice will be posted online and in newspapers stating that the lessee has passed away without naming a successor to their lease. Relatives of the lessee will then have 4 months from the public notice to respond to DHHL to claim successorship and to prove their eligibility. So those who fail to present themselves within that 4-month time period will be barred from trying to succeed to that lease. And so eligibility here, it means not only do they need to show that they meet the blood quantum requirements, but they also must show that they are related to the former lessee. And usually this is accomplished just by providing a birth certificate to the department. After confirming eligibility, the department will make a recommendation to the Hawaiian Homes Commission on who to designate as successor. The commission will designate a successor at their regular monthly commission meetings. After that, the department will then notify successors that a lease transfer needs to be signed. As I mentioned, this is a lengthy process. Public notice could be published months after the lessee's death. Then there's 4 months that must be allowed for relatives to respond to the public notice. Then there's the time it takes for DHHL to determine eligibility, that is the legal relationship and the blood quantum of potential successors. So how does the department choose a successor? That is, how does the department choose a successor from those who responded to that public notice? Now, the Hawaiian Homes Commission Act determines the order of priority. The lessee's family do not have control over who ultimately gets chosen by the department, as the department has to follow the Hawaiian Homes Commission Act. So really the only way around following the statute's order of priority is by designating a successor. Again, those who respond to the public notice must be eligible. So if you look at this pyramid, what you'll see here is the order of priority. And first it's spouse. If there is no spouse, then children. If no spouse or children, then grandchildren. If no spouse, children, grandchildren, then siblings, and so on. If no successor is chosen by the department, the lease will be canceled and the net proceeds, which I'll talk about in a little bit, will be paid to the deceased lessee's estate. So ultimately, even if you have 100 family members who fall within this pyramid, if no one responds to the department within those 4 months from the public notice, the lease will be canceled and the net proceeds paid to the lessee's estate. So the takeaway from this section is if you do not designate a successor to your lease, the department will attempt to select one for you. This process is long and could take many months, and the lease may not pass to anyone in your family and instead may be canceled with the net proceeds paid to the lessee's estate.
Hi, everyone. This is Kuila Kapra. I'm the Director of Litigation at NHLC, and sorry for the late introduction, but I'll be on today with Henderson. And I just wanted to add one other thing that I think is worth mentioning based on the cases we've seen is that while this is a long process that does have uncertainty in it, the other wrinkle is that you also have to act, or your family has to act very quickly once the notice goes out, like Henderson said, 4 months. And with the added hoops that your ʻohana would need to jump through if no successor is named, that's just another reason why naming a successor really is important. And that's based on what we've seen in our cases here. Thanks.
Exactly, yes. Thank you for that, Kawila. So now we get to talk about what happens after a lessee passes away with a designated successor. This process is shorter than the previous process. It has more certainty, but it still does take a little bit of time. And it starts similarly to the previous process in that it starts when the department receives the death certificate of the lessee. So once they receive that death certificate, they will send a letter to the designated successors, which then ask whether they would like to succeed to the lease. If they would like to, the department will then confirm their eligibility. And in order to be eligible, they need to be related to the lessee and have the minimum blood quantum. DHHL may ask for the successor's birth certificate if they don't already have it to confirm eligibility. Now, with the department's current processes, sometimes they will ask for additional documents to verify the successor's blood quantum. In the past, successors have relied on the records that DHHL has to verify their blood quantum, but with their new blood quantum recertifications, the successor may be required to provide more information or go up higher in their genealogy than they previously did. So for example, this may mean providing vital documents such as a birth certificate or marriage certificate for relatives going back to the successor's great-grandparents. After the department confirms eligibility, they will make a recommendation to the Hawaiian Homes Commission to approve a transfer through successorship, which is done at their monthly commission meetings. After the commission approves that transfer, DHHL will then notify the successor that a lease needs to be signed. So this is still a bit of a lengthy process, but it definitely is shorter if there weren't a designated successor. So that's why it's best to make sure that you have a designated successor and that designation is proper and that there's no issues with it. Now, what are a lessee's rights in designating a successor? Ultimately, it's the lessee who gets to decide who they would like to succeed to their lease. However, the lessee must choose a legal family member with the required blood quantum. The lessee has the right to change their designation at any time, and if they choose to change their designation, the lessee nor the department are required to let previous designated successors know of that change. Additionally, the lessee does not need the permission of co-lessee or their spouse, co-mortgagor, children, their lender, or current designated successors if they want to change who they would like to be their successor. And the next point is that the designation is confidential. So only the lessee and the department have access to that information. Not even the designated successors have access to that information. And last, a lessee cannot be forced to name a successor. Instead of designating a successor, the lessee may instead choose to have the net proceeds paid to a named person, for example, a spouse or children that do not meet the blood quantum requirements. So let's look at blood quantum requirements under the Hawaiian Homes Commission Act. So these requirements are outlined there. The department, the lessee's family have no choice in what the blood quantum requirements are as it's outlined in this act. I would like to note, however, an amendment was approved by the state legislature to reduce the blood quantum requirement for successors, specifically children and grandchildren, from 1/4 to 1/32. However, that amendment is still subject to the consent of the United States Congress, so it is not yet valid. So the way to understand blood quantum requirements for successors is to think about it this way. So if we're looking at this sort of diagram or family tree with the lessee in the middle, if you go straight down to children and grandchildren, or straight across to the siblings of the lessee or the lessee's spouse, the successor only needs to be 25%. However, if you go straight up to parents of the lessee, or nieces and nephews, or surviving spouse of the children of the lessee or surviving spouses of the siblings, those successors need to be 50%. So let's talk about some of the other requirements that there are for successorship, such as the legal relative requirement. Now, what that means is that the successor, the relationship of the successor, it must be recognized by law. So essentially, informal Hanai family members will not be recognized by the department because they are that relationship is not recognized by the law. There must be a legal adoption with a birth certificate if you would like to name that person as a successor. The state of Hawaii does not recognize common law marriage, so therefore common law spouses also will not be recognized by DHHL. If you would like to name a spouse as your successor, there must be a legal marriage with a marriage certificate. And so last, stepchildren are not recognized as legal relations unless they are formally adopted. So on the note of adoption, how does adoption affect successorship? Adoption does not change the blood quantum of the adoptee. Rather, their blood quantum is still determined by their biological relatives and not their adopted relatives. So the adoptee still must, or the adoptee successor still must provide the vital documents of their biological relatives to prove their blood quantum in order to succeed. Now, the adoption record law was amended in 2016, which allows access to adoption records that were granted in the state of Hawaii to adult adoptees, their natural parents, and their adopted parents. The form to access these documents is available on the judiciary's website under Family Court Self-Help Forms. Additionally, the department has the ability to obtain those ancestry information if the adoption records are sealed. Next, adoption generally changes the legal relationship of family members. And what that means is adoption legally severs familial rights and familial inheritance. So let's look at an example of how adoption may affect lease successorship. So let's say that there's a grandparent who adopts their adult grandson. That grandson then inherits a lease from the grandparents that are now his legal parents, and he wants to name his biological sister as his successor. However, due to that adoption, she is now legally his niece, and she must have the 50% blood quantum. The 25% blood quantum that applies to siblings no longer applies here because she's legally the niece. There is an ʻohana adoption exception that in the past NHLC has argued applies to DHHL successorship, but I want to note that this issue has not yet been decided by the courts, so there is no established rule. Under this ʻohana adoption exception, the familial relationship and inheritance rights are not severed in the case that a minor was adopted within the family. So that exception does not apply if the adoption took place after the adoptee turns 18. So the takeaway here is that a lessee can only choose a successor from specific legal relatives with the required blood quantum.
Yeah, I'll add here one question that we receive a lot and we have gone over the years is, well, how can I use adult adoptions to make sure that I can pass my lease to someone that I want, and that is available, but I think like any other adoption scenario is not without its complications and like specific issues there. So I think in all of those situations, if an adoption is involved, we would highly recommend that you contact an attorney for advice on what would happen, especially in the case of an adult adoption for a DHHL purpose.
Exactly. Thank you. Now, how is a
Henderson, real quick, I just want to let people know we've got a number of people that have joined since we started. So to folks who have joined and didn't hear it at the beginning, please feel free to use the Q&A feature at the top of the screen for any questions that you have, and we will take them at the end.
Thanks. So how is a successor designated? The process to designate a successor is outlined in the Hawaiian Homes Commission Act. And in order for a designation of a successor to be valid, it must be in writing on DHHL successor designation form. And that form then needs to be filed with the department. They have to have it. And third, it needs to be approved by the department. The lessee or the designated successor must provide proof of the successor's eligibility. So again, that usually means at least providing the department with at least a birth certificate of the successor in order to show at least the relationship to the lessee. Now, the rules or the administrative rules are not clear on when such documents are required, but it is best to provide them at the time of the designation in order to avoid any delays in the future. Failure to adhere to these requirements will result in a void designation. So what that means is if there's something, if the designation wasn't in writing or it wasn't filed with the department or approved, then that person that you would like to succeed to the lease will not be able to do so. And it goes through that public notice process that I spoke about earlier. And last on this slide, a lessee cannot designate their successor by will or contract. It must be done through this process that the Hawaiian Homes Commission Act outlines. So on the side, you'll see an example of the successor designation form, which is provided by the Department of Hawaiian Homelands. And if you would like to designate a successor to your lease interest, please contact them. Please contact the Department of Hawaiian Homelands so that they can provide you with this form. But what we'll be doing now, though, is taking a look at this form. And in the first part, or part A of the form, the lessee provides their basic information, so name and contact information, as well as basic information about their lease. So that's lease number, the lease type, the lot number, the tax map key, and property address. If you don't know what the tax map key or the lot number is for your homestead, you can go to your county's real property tax records website and enter in your address, and it will pull up that information for you. In the next section, this is where the lessee designates their primary successor, so part B1 of the form. And here you'll be asked to provide some information about the successors. And again, it's important to make sure that that information is correct and accurate so that there are no future delays. Now, if the lessee would like to name multiple successors, the form will ask what sort of tenancy they will have. And if you look here, there are 3 different types of tenancy. Now that choice is important because it will determine or impact how the successor's interest in the lease interact with each other. So the first one is joint tenancy. And in joint tenancy, all of the co-lessees, all of the co-successors, they have an equal and undivided interest in the lease. Now, when a co-lessee passes away, their interest automatically goes to the surviving co-lessees. It doesn't go down to a successor. The next is tenancy, tenancy by the entirety, and that is basically joint tenancy, but for married couples. So in that one, when one spouse passes away, their interest automatically goes to the other spouse. And the last is tenancy in common. And this one is very different from joint tenancy. And in tenancy in common, all of these successors have a distinct, or they're entitled to a separate and distinct interest in the lease. And that when they pass away, their interest is able to go to a successor. So I know for most, it may seem like the natural or fair thing to do is to name all of their children as successors to a lease. However, naming multiple successors to one lease may create conflict, so it's important to know these issues and to be honest with yourself about how they may apply to your own ʻohana. So first, let's talk about the rights of co-lessees. Now, co-lessees have equal rights to the lease. That also means that they have an equal kuleana under the lease. And as each co-lessee has an equal right to that lease, they cannot be forced to sell or surrender their interest to the other co-lessees. Now, to ensure stability in designating multiple successors, there should be some sort of mutual agreement over the management of the homestead and its lease conditions, such as paying the mortgage or taxes and maintaining the homestead. So for residential leases, it is a requirement that all lessees reside on the homestead, and this may turn out to be problematic. And say, for example, having maybe 4 co-lessees all with their own families. And in that situation, you can imagine where there might be some challenges when it comes to living arrangements. Another area of disagreement among co-lessees is the sale of the lease. Now, homesteaders are able to sell their lease to qualifying Native Hawaiians. Now, in the case where there are multiple lessees, all must be in agreement to sell the lease. Now, these sorts of disagreements over the management of the lease, they may actually result in some lease violations. And I would like to note, though, that in the case where there are disagreements among the co-lessees about the management of the lease, there are alternative dispute resolution options available, such as ho'oponopono, if that is appropriate for your family, or mediation, where a third-party neutral mediator helps the parties involved come up with a solution to their issue. These options, may be used to work out some of these problems, as well as prevent lease cancellation should that be the case. As I mentioned in the previous slide, there are different types of tenancies that successors may have, that a lessee may designate for their successors to have. Now, with joint tenants, the surviving co-lessee inherits the interest of the co-lessee that passed away. Now, with tenants in common, the co-lessees are able to name their own successor. And so that can lead to an increase in the number of co-lessees, and that may be problematic. So let's say a spouse of one co-lessee succeeds to their interest. That may lead to your ʻohana being co-lessees with the in-laws' families, not just your own family line. So in this example, what ends up happening is there are 2 different families able to succeed to this one lease. I'd like to now turn to issues that may come up with designating a minor as a successor. And again, I know and understand that really this is the natural tendency to want to leave your lease to your children or even grandchildren. So there are just a few things that lessees should be aware of so that they can plan for the success of their successor. Now, designated successors who are minors, that is those who are under the age of 18, when the lessee passes away, face additional challenges. So right now, DHHL, they require that a conservator be appointed by the courts in order for that minor to take over to succeed to that lease. And this starts really with that person, that conservator, potential conservator, requesting or putting in an application to the courts. If they are appointed as conservator to the estate or to the the lease, there are certain responsibilities that they will have, such as yearly reporting on the conservatorship and the management of the lease to the courts. A conservator becomes responsible for the management of the lease. So that means making sure that the mortgage, if there is one, and the taxes are paid and that there are no lease violations. This responsibility remains until the successor turns 18. But even then, the conservator must petition the court to discharge that conservatorship. So it's important to plan with your family or those who you trust who might be able to serve as conservator should the need arise. Now, a conservator does not need to be native Hawaiian, as the lease, it remains in the minor's family or the minor's name, and it's the conservator who manages the lease. So going back to the designation form in part C1, this is where the lessee is able to name alternate successors. And it's very similar to the last. And in this section, the difference is that these are backup successors. So those listed here are only able to succeed to the lease if those named in the previous section, the B1 section, do not want to succeed to the lease, or they passed away. Now, being on this portion does not guarantee that the person will succeed to the lease. So the wrap up here is that you must use DHHL successor designation form because the designation needs to be in writing, needs to be approved or filed with the department and approved by the department. The other thing to remember is if you want more than one successor or a child successor, there can be unexpected challenges. So in those instances, extra planning is needed.
You know, that's an issue. Like, we definitely know that it is the choice and of the lessee to choose how and whom to pass their lease to, and for a certain family it may make sense to leave it to more than one individual or a child. But I think that point of extra planning, that's really important, because there are things that you can do, right? Like, in the for example, in the situation where you want to leave a lease to multiple adult lessees, you can talk about, well, can there be agreement about how to both reside on the lease? In some situations, it's possible to even subdivide, but those are things that should be worked out ahead of time. So all of these things can be addressed, but it does take advanced planning.
Exactly. Really, the key to all this is to plan these things in advance and to talk with your family in advance. Now, I mentioned a couple times throughout this presentation, net proceeds. So what are net proceeds? Net proceeds are the appraised value of the improvements on the homestead minus any money that may be owed to the department, so that if there's a mortgage on the property or any real property taxes that are owed. Improvements are the house and other permanent structures on the homestead. If it's a agricultural lease, that also includes crops. And so there are 3 different options available for the appraisal of the improvement on the homestead. And the first is a disinterested appraiser chosen and paid for by the department. The second is a disinterested appraiser chosen and paid for by the department and the lessee or the lessee's representative. And the third is no more than 3 appraisers being chosen. The first paid for by DHHL, the second by the lessee's representative, and the third paid equally by both. Now, payment of the net proceeds, it's generally made after the homestead is awarded to a new lessee. Once that happens, the net proceeds are paid to non-qualifying spouse, or children, or the lessee's estate. Now, if it is paid out to the lessee's estate, or needs to be paid out to the lessee's estate, that estate will need to be probated in order for the department to make that payment. So what that means is there needs to be an executor of a will of the deceased lessee, or a personal representative of the estate of that lessee. And that usually requires a petition to the courts. So returning back to the designation form, a lessee is able to designate the non-qualifying spouse or children to receive the net proceeds. And what I mean by non-qualifying spouse or children, that is those who are unable to meet the blood quantum requirements. So for spouse and children, it's 25%. So if those relatives are unable to meet the blood quantum requirements, you can list them here to receive the net proceeds. You can also notice on this side that the lessee is able to determine the percentage of the net proceeds that each designee shall receive. If the lessee doesn't put in a percentage, each designee will be paid equally. So again, this portion of the form is only completed if the previous section, the previous successor portion is not able to be filled out, or the lessee chooses to designate, or excuse me, or the lessee chooses not to designate a successor to their lease. A quick important note for net proceeds and non-qualifying spouses. As I mentioned previously, the lessee is the one who gets to decide who they would like to be their successor to their lease. And that may be contrary to what the non-qualifying spouse may want. Now, in the event that a lessee names a successor who is qualified to succeed, the non-qualifying spouse is not entitled to the value or the net proceeds of the lease. Additionally, the lessee is not required to designate their non-qualifying spouse to receive those net proceeds. It's up to them how they would like the net proceeds to be paid out. So they may perhaps choose to only designate their non-qualifying children to receive those net proceeds. So it's all up to the lessee on what they would like the net proceeds, how they would like that paid. And so to recap, a lessee can designate a spouse or children that do not qualify for lease succession to receive those net proceeds. And those net proceeds are the value of the improvements on the homestead lot minus any debt that might be owed for taxes or a mortgage or anything owed to DHHL. Now, in wrapping up with this designation form, the last portion for the lessee to complete is the signature portion. So the signature needs to be witnessed by 2 witnesses, and by signing the form, they acknowledge that they're revoking any of their previous designations. So anytime a new form is submitted to the department, it does away with previous designations that the department may have on hand. And so when processing a designation form, the department or DHHL, they verify who the lessee is through state of Hawaii recognized identification, such as a state driver's license or state ID. Now, if a lessee does not have these sorts of identification, there are resources online to help in obtaining these forms of identification and can be found at lawhelp.org/HI. All right, and so turning now to waitlist successorship, a lessee, or excuse me, an applicant, a beneficiary on the waitlist, they are able to designate a successor to their waitlist spot. This process is a little similar, but to that of lease designation successorship, but it is different. So the successor succeeds to the applicant's spot on the wait list, their number. It's not for a lease. So that means the designation is limited to one successor. And that successor must be able to essentially apply for a homestead themselves. So they have to be at least 50% Native Hawaiian and at least 18 years old. On the right side of the slide, you'll see a list of eligible successors. So it's, again, spouse, children, siblings, parents. Those are the relatives that are able to succeed to a waitlist spot. And really the way to know whether you can name somebody to be your successor to a waitlist spot is to ask whether that relative is able to apply for a homestead lease themselves. So if they can't sign up for a lease and go on the waitlist themselves, then no, they cannot be a successor. But if they can, then yes, you can name them as successor. So what happens after a waitlister passes away without a designated successor? This process is very similar to the process where a lessee passes away without a designated successor. And it starts with the department receiving the waitlister's death certificate. After receiving that death certificate, they will publish a public notice online and in the newspapers saying that the applicant has passed away without a successor. That public notice will have 4 months for the relatives of the waitlister to respond to that public notice claiming that they would like to succeed to that spot on the wait list. So they'll also need to provide proof of eligibility so that they are, one, a relative of the waitlister, and two, that they meet the blood quantum requirement of 50%. After that public notice period ends, within 1 year after it ends, the department will make a recommendation to the Hawaiian Homes Commission to designate a successor. The commission will then designate a successor at their monthly commission meetings. And if a person disagrees with that commission decision, they may request a contested case hearing. After that, the successor then takes the spot on the wait list. Now, the department's administrative rules do determine the order of priority of those responding to that public notice. The applicant and the applicant's family don't have any control over that priority. And as I mentioned previously, the only way to get around that priority preference is to designate a successor. So the order of priority is the same as the order of priority for when a lessee passes away without a designated successor. So it is first spouse. If there is no spouse, then children. If no spouse or children, then grandchildren, and so on. Now, if the successor, or if a successor is not chosen by the department will cancel the application. So important things to remember here is if you do not choose a successor to your spot on the wait list, the department will attempt to choose one for you. And the other important thing to remember is that waitlist successorship is for the number, the spot on the waitlist. It does not give the successor a lease. So they need to be eligible to apply for a homestead themselves, meaning they need to be at least 50% Native Hawaiian and be at least 18 years old. Now, there are some other considerations in designating a successor that I'd like to go over. Mainly, designating a successor who already has a homestead lease. A lessee is able to designate a successor who holds the lease. However, that successor will be prevented from succeeding to the second lease unless they transfer or surrender their current lease. The department also treats successors whose spouse has a lease the same way. And so they will require that spouse to transfer or surrender their current lease before the successor spouse is able to succeed to that second lease. Now, NHLC has argued with DHHL in the past that there is nothing in the Hawaiian Homes Commission Act or administrative rules to treat a spouse's lease as preventing successorship from happening. And that is not to say that we support having two leases, but that they should be allowed to succeed to that second lease in order to transfer it. I'd now like to turn to some questions with successorship when there is a mortgage on the homestead. Now, non-lessees or non-qualified spouses must be aware that being a co-mortgagor does not guarantee rights to the lease or the net proceeds. Now, if there is a mortgage on the homestead, it's important to know that the successor will be responsible for that debt. So when they take over the lease, they also take on that debt. And that may require that successor to get another mortgage in order to pay off that debt. So lessees should discuss with their successor any mortgage amount balance and monthly payment so that they can plan. A discussion on this will allow for the successor to know what their mortgage kuleana is or will be, because being caught off guard, it makes it harder for the successor to succeed in this homestead. It's also recommended that designated successors reach out to credit counseling to help them prepare for home ownership and help them prepare their credit in case they need to apply for a mortgage themselves. Last, I'd like to note that if possible, mortgage payments should continue to be made during the period between the lessee's death and the successorship. And that's done to avoid any fees or penalties, as that's still, the mortgage is still going on even though the lessee has passed away. So the point to remember here is, and really this whole webinar, it's talk with your designated successor and with your ʻohana now. Talking to your successor now allows for planning. They can start planning, especially if their spouse already have a lease or if there is a mortgage on the property. This talking and discussion will allow them to plan on how they might be able to pay for that mortgage. Now, in wrapping up, I'd like to just quickly go over how to request legal services from the Native Hawaiian Legal Corporation. That request first starts with an initial contact to our office, either by phone, so 808-521-2302, or online at our website at nativehawaiianlegalcorp.org/contact. Now, after your initial contact, our intake staff who are very friendly, who will follow up to gather brief information from you. So that includes your name, your date of birth, your contact information, and a brief description of your issue, as well as the names of those who might be involved. We will then do a conflicts check based off that initial information. Now, this is something that all lawyers are required to do. And that's because lawyers have an ethical duty to be zealous advocates for their clients. And part of that duty requires them to not take on cases or clients that present a conflict of interest with their other cases and clients. So a basic example of a conflict where there's a direct adversity or being directly adverse to one another is where, say, there's a bitter disagreement between two co-lessees. That attorney cannot represent both of those lessees as their goals are directly adverse or they're opposite of one another. Another example of a conflict would be one where the attorney is materially limited in representing a client. And so in representing one of those co-lessees in a case, the other co-lessee may seek representation from that same attorney, but in a different matter in a different case. Although it's not directly adverse, the attorney may not may not represent the second co-lessee if it would materially limit the representation of the first co-lessee and vice versa. Now, after you clear our conflicts check, our intake staff will contact you again to fill out an e-form, and that is to provide more information about your issue. If you do not have an email address or access to the internet, our intake staff will then contact you by phone to fill out that information. Once we have that information, NHLC's small but mighty team of 6 attorneys meet to discuss your inquiry, and then an attorney will follow up with you. So with all of that said, I would like to say a very big mahalo to everybody joining us this evening. So we'll be opening it for questions. If you have questions and haven't already done so, please use the Q&A function at the top to submit your questions. If you have a specific question or a question specific to your situation, please contact our office to open an inquiry. Thank you.
Thanks so much, Henderson and Kauila, for sharing all of your knowledge and insights into what these matters look like and ways that families can be a little proactive about what happens when it's time for lease successorship to occur. So we've had questions submitted through Q&A, and we're grouping them together so that any questions that are similar we'll kind of ask at one time. Just want to remind folks that there is a Q&A feature at the top of your screen, which you can use to send us questions, and we get them backstage and we're preparing, don't worry, we're getting them. We're preparing our answers actually throughout. So to get started, Henderson, a good question from the start of your presentation came through. Where does DHHL publish the public notices when someone dies without a successor form?
That's a really good question, so mahalo for that, whoever asked that. The public notice is published online at DHHL's website. There's a little tab or button that shows notices, and if you go there, you can see the various public notices that are published. They also publish it in the newspaper, so in the advertiser, in that legal notices section, there will be notices there.
Great. Another question came through. Will there be a change soon to the blood quantum for successors so that you can inherit the lease if you have less than 25% blood quantum? Kauila, do you want to share some on that?
Yeah, no, that's a good question. I know Henderson covered that. That amendment, there's an amendment reducing the blood quantum for successorship down to 1/32, which I think has some historic significance as like one of the metrics that was initially sought by Prince Kuhio. But all to say is that was passed by the state. It still needs approval by the federal government. And there is no public or published timeline for that approval. Until that happens, unfortunately, that change cannot take in effect.
Okay. Mahalo, Kauila. I know that this is a challenge for many families, and so I hope that we get relief for our families on that. Okay, so another question. Someone is asking, when you look at the HHCA, where does DHHL get authority to manage this program under the HHCA? The whole Hawaiian, I think it means the whole Hawaiian Homestead program.
Yeah, no, that's a good question, and I think probably good for a longer discussion. It is in the Hawaiian Homes Commission Act in Section 202, but we recognize that that was an amendment, so it wasn't in the original version of the act, and that happened during the process of Hawaii being admitted as a state. So I think we're aware that as part of Hawaii being admitted into statehood as a compact with the federal government, they agreed to take on management of the act. So it is in the act, but it was in addition after the fact.
Okay. I have a few questions from the audience through email and through the chat that are wanting to understand a little bit about how these blood quantum rules work. So Henderson, I'm going to try to give you a couple of scenarios and see if we can trace and provide some examples of how you apply the formulas, okay? So one that came through says, I currently have a lease that I received from my grandmother. So she's the current leaseholder. I have no children and I'm an only child. So no children, no siblings. I want to leave my lease and my home on the property to my first cousin's daughter. So I think that would be first cousin once removed, I think. She does not have 50% blood quantum. Can I do that?
Okay, yeah, that is sort of an example of how the act in its current form is limited. And so if you go back, let's actually go back to the list of those who are able to succeed to a lease. So in this diagram, it's only siblings and spouses in the same generation of the lessee. It doesn't take into the act itself, the Hawaiian Homes Commission Act doesn't take into account cousins. So in this situation, the person asking, unfortunately, would not be able to designate their cousin as a successor. The only way that they could try to get that lease to that cousin would be for them to be 50% Native Hawaiian.
Okay. Yeah, great example of how difficult these rules can be when applied to families. Another question. My grandfather was on the wait list since 1972, and it sounds like did not come off the wait list before he died. And I think the question is twofold. One, does a relative get to succeed him on the wait list? And if so, does what blood quantum is required?
Yeah, so there's a couple things that would be important here. And it's first, whether that relative is still on the wait list. So if their name has been removed because the department did in fact receive the death certificate for that beneficiary applicant, then it's most likely that their name has been removed. But the name is still there. The process would be that the department needs to be notified of the applicant's death. So that's providing the death certificate. And did you say it's a grandparent?
It would be well, it's the person asking it was their grandfather, but it's their mom who's trying to succeed on the wait list.
Okay.
So
okay.
it would have been the person on the wait list, their child.
Okay, yeah. So to succeed to the wait list, whether it be child, grandchild, or anyone else that's able to, because it's a wait list application spot, that person needs to be 50%. Because really they're going on the wait list themselves. They're not getting a lease. So they need to be able to be eligible to apply for a homestead themselves.
Really helpful, Henderson, and not at all obvious when you think about how this might work if you're not reading all of these rules. So thank you so much for that. Okay, another question. Well, so there's a number of questions around scenarios on how these rules work. So I got one other one for you. So someone's asking, I want to name my minor child as a successor. So this is an issue involving a minor. Can I also name who I want to be their representative, or is the court going to assign the representative? That's one question. And then does the representative have to have blood quantum?
That's actually a really, really good question. So thank you to whoever asked that question. Now to the first question of whether a lessee is able to designate who they would like to be conservator for their minor successor. On the current DHHL designation form, there is no area or way to designate who that conservator will be. And that's really because that whole process takes place outside of the Department of Hawaiian Homelands. It takes place in the judiciary before the courts. So there may be ways, and again, you should consult with an attorney on this matter, especially for if there's a specific situation that you're trying to navigate. But there may be ways to demonstrate an intent of who you would like to be the conservator, because that may be something that the courts will look at. So if somebody designates a person who they would like to be the guardian of their child should they pass away, the court may look at that as the intent of the parent to have that person also serve as the conservator.
Okay. I'm
Oh,
shifting
and I
now.
think
Oh,
there was one other portion of that question, that does the conservator need to have
Yes.
local to to be a conservator, and the answer to that is no, they do not.
okay, thank you for catching that.
Thanks.
Okay, and folks, please feel free to keep the scenario questions coming, because I do think how these rules play out, examples are helpful. We want to respect your privacy, so we'll keep them anonymous, but don't mind sharing sort of the scenarios of the family and trying to fit them in the way we just did. But that's all of those that I see so far. So let me shift to a different kind of question. So Koila or Henderson, someone is asking about how the Kulāiwi case fits in with this topic. Can you share anything about that? Maybe even just a little bit about what the Kulāiwi case is and how it fits in with successorship.
Right. So the Kulāiwi case is based on a legal process that was established by law that essentially no longer exists, and so there's a limited universe of beneficiaries who were able to sue or go to court over their dispute with the state when it comes to the administration of the Department of Hawaiian Homelands and the trust. So to frame it as, could there be, a follow-up to Kulāiwi? Not in the exact same way, because that was a very, specific legal process that's no longer in play. But is there a question about, hey, how can we get, some sort of legal relief from the courts especially for those on the wait list, for, designated successors to wait list spots? That I think is a different question. And, in fact, we were involved in the Nelson lawsuit, which was based on the high number of waitlisted beneficiaries, but to increase funding from the state to these programs to remove those beneficiaries from the waitlist and get them on the land, right? So there could be other forms of legal relief. There's nothing prohibiting someone or preventing someone from filing class actions against the department. It's just, what will that look like? The ability to sue the state for money damages is limited, but there could be other things that you ask the court to help with. So it's possible there could be something there, and again, it really is consulting with the attorney. So would depend on what you're looking to accomplish, and that's something we would love to have a conversation with you about. If you were to go through our intake process, give Grace a call, and we like every call that comes to our office that passes our initial screening is answered by an attorney, and we'd be happy to discuss that with you.
Okay. Just want to keep encouraging people to send questions in. I think we probably have time to answer maybe up to 4 or 5 more, but I really only have 2 more. So if anybody has one or two more questions they want to submit, please feel free to answer them. But so maybe the last two questions, guys. One, I think I just want to make sure we got to it. I think you kind of answered it earlier, Henderson, but just to be sure, back to cousins. So cousins and second cousins, can they be designated successors? Yes or no?
Again, the short answer would be no. It's really just limited by what the act says, and this is basically those who can succeed.
Okay, and that chart is really helpful.
Mhm.
Thank you. Okay, one more question. What should I do if I see a notice for a lease succession by DHHL? So one of those notices you talked about where someone didn't have a successor form, and so DHHL published it. What if I see a notice like that for one of my family members? What should I do?
Okay, that's another really good question. And it really starts with what you would like to do. So if your intent is to succeed to that lease, that is take over that lease, then I would say contact the department and let them know that you want to succeed. You also have to remember that you need to provide proof that you are related to the deceased lessee and that you have the requisite blood quantum. So you should also, prepare those documents and make sure you can pull those up in responding to the department. But I believe it's just initially calling the department, and I think the public notice may give specific contact information on how to respond to that notice.
Okay, so ask and you shall receive. So I have a few questions, more scenarios. So let's try to get through at least two, but then for the audience, I'm really excited that so many people joined us. We had between 40 and 50 people on the line this entire time. If we didn't get to your scenario, just want to really reinforce that you can call our office, but let's try to get through a couple more. So this one raises a question about adoption in a family. So the person asking the question has a lease. Their spouse was legally adopted by his grandparents. Oh, I'm going to try to make sure I get this right. So for the spouse's biological mom is on the wait list. I think the question is, can that spouse succeed to the lease?
Okay. Well, if the question is whether the spouse who was adopted can succeed to the lease, the short answer is basically yes, so long as they are able to show that they have the right blood quantum. So in this case, if the spouse knows that their biological parent is on the wait list, that is a good indicator that they're at least 25%, and spouses need to be at least 25% in order to succeed. But again, it really all depends on the documentation that they're able to get. So if that documentation is made available to them, they should be able to use it to show their blood quantum.
I would add to that, whenever you have situations with adoption, which can come up in all kinds of situations. First of all, I think a question like that, like asking that and wanting to figure that out is really good. The minute there's any question from DHHL or any issue with that, again, I would reiterate, talk to an attorney. Because when it comes to adoptions, there are things that can have that are available in some situations and not. And I think it always helps to be a squeaky wheel sometimes at the department to try and get an answer, because it's also an option that maybe they won't find an issue or come up with an issue until after a lessee's death. And so I think it always helps to push the department to, accept and approve a named successor while the lessee is still alive.
Okay. One more. So I am a lessee. I became widowed and I have an adult daughter. who's 25% Hawaiian blood quantum, and I'm remarried to a Hawaiian who is 50% blood quantum. But if I leave my present spouse as successor, will my daughter qualify as a successor via my present wife? I think the question is, could I name my present wife as successor, and then could my daughter succeed after her?
Okay, so
I believe, yeah, under that scenario, and would be no, because your daughter would not be the legal daughter of your wife. Correct, Henderson?
yeah, that's right. The daughter would need to be adopted in order for there to be that legal relationship, in order if the intent was for them to succeed to the lease.
Yeah, and I think we could comment and say, that's a rough one, just because
Mhm.
that's not how all families work, right? Like, you often don't need pala to say someone is a daughter or not. And that's, I think, the unfortunate part that I think we probably all agree is unfortunate. A lot of the laws and rules here is because it's not based on any like traditional practice or custom or just ways of living that's relevant to what our community has experienced. So like it makes sense that there are questions about this because these rules don't always, jive with how we're raised and how we live, So I think that's a really good question, and it hopefully, and I'll just flag that as like this is why, involvement like this and seeing like just the growth in grassroots based leadership is good, because I think that's what we need to eventually change the program to be more consistent with the way that our community operates. So really, really good question to bring that up.
Mhm. Okay, so I have there's a couple more questions. So I just wanted to flag one. And the person who submitted this, I hope you're still on the line. There is a question about a fact pattern that I think is a little more complicated and will be good to call our office about, regarding an uncle who had applied before Hawaiian statehood, and just asking some questions where I think we could help, but please call. I think that one will be hard for me to really explain to Henderson verbally because of all the details. So just noting it, because I don't want you to feel like I didn't see it, but would really be grateful if you could call so that you could really explain that one, because it's more complex. Okay, and then the last question then is a question about how you qualify for help from NHLC. So this is a good one. I think all three of us could maybe chime in on this one. But the question is, if there's no conflict of interest, what else do I need to qualify for services from NHLC? What does NHLC require to be a client? Is I think basically the question.
All right. Henderson, maybe you can walk them through the process, and we can expand on that.
Okay, yeah. So I guess we can just go back to this slide. And so once the conflicts check, right, goes through and there is no conflict, intake staff will gather the more information, and all of our team of attorneys will discuss that inquiry, and an attorney will follow up. So once that initial or additional information is taken, NHLC will look at that issue. But however, that doesn't guarantee legal representation. So each inquiry is overseen by an attorney who will, follow up and, if necessary, do some legal research to see how it is that we might be able to help you. Because not in every inquiry or request of services to our office is a full-blown case needed. Sometimes it's just simply really giving information or pointing the caller in the right direction.
Yeah, I would say, to supplement that, Henderson, if the question or issue that you have falls within the areas where we work, and Henderson talked a little bit about that, but the short answer to that is law specifically relating to Native Hawaiians is work that we do. Other laws that are not specific to Native Hawaiians, those are probably less likely. So, you know, we currently don't do criminal law things. We don't currently help with divorces, that kind of thing. But if you're asking a question that relates to Native Hawaiian law and rights, good bet it falls within our scope. So that's one thing we're checking for. The conflict of interest is another thing we're checking for. The thing that people often also want to know is whether or not, how affordable is it? And so far as we have no fee or low fee, you know, how do you qualify for that? What I can say in short there is, frankly, most clients of NHLC do not pay if you are indigent, which means, you know, do not have the financial means to pay based on federal standards. You definitely do not pay. We have grant support that covers that. And even if you have the financial means that would, at least from a federal standards perspective, say you have means, we understand that legal services are expensive. We offer low bono rates for cases where we do ask for contributions from our clients to help keep our lights on. But we offer really flexible payment plans too. And it's our belief that hardship paying should not be a barrier to legal services. So please don't let that be a reason that you don't call us. We do not want that to ever be a reason that clients feel they can't get the help that they need. So, okay, with that, I think this contact information is there so that you please come reach out to us in any of the ways that you're comfortable, phone, email. There's a contact us form on our website that you could use as well. So please feel free to contact us. I hope that we got to all the questions. If we didn't get to all of them, I greatly apologize, but I'm sure that Grace would be happy to take your call tomorrow or anytime. Thank you so much to everyone for attending. And thank you, Henderson. Thank you, Kawila.
Thank you, everybody.
Good night.